for those of you who need it. I want to thank all of you for joining. For those of you who maybe don't know me, I'm Quinten Cupps with Vial Fotheringham, or VF Law, you may hear us referred to as. I'm an attorney with the firm. I've been practicing in this area of law since 2008. And this is our 2022 legislative update. And I'm proud to report that we actually have some cases to talk about this year. I know it's been kind of light the last couple of years for various reasons, but we do have some things that we need to go over this year, as there will be a change in the way things are done in our community. So just some ground rules. I would hope that if you have any questions, you are willing to ask them. Please feel free to unmute yourself and interrupt me at any time if you do have questions. I think that is helpful for everyone to kind of hear various perspectives and questions. I think we all learned from that. I did, as Terry mentioned, there is a chart in the chat that you please download, and you can follow along on that chat. It's a summary that I put together of the 4 bills that we're going to talk about today. And then as time permits towards the end, I hope to be able to go over some of the recent case law that has come down in the various courts here in Arizona. So let me get started here. So just throw some numbers out here. So I have the opportunity to serve on the Legislative Action Committee for CAI. I've had the privilege of doing so for the last, I believe, 6 years, and I'm one of the co-chairs this year. And so we were very heavily involved this year in behind the scenes and in the process of finding bills as they came to the table, having stakeholder meetings, going down to the Capitol and meeting with representatives, sponsors of the bills to try to either defeat some of the crazy bills that were put on the table this year, and more importantly, to try to revise some of the bills that had a lot of support that weren't great when they were first drafted. So it's been an interesting session. Unfortunately, the session is not over yet. We thought in planning this class, we thought that it would be, but some things have come up that have caused delays, and I don't know when it's going to end. As a committee, we usually meet once a week to talk about the changes. We haven't met for about a month because nothing's happened that's worth talking about. So we're hopeful that in the next couple of weeks it will end. I'm sure you will hear from one of many law firms once it does end, because that starts the clock running on when these bills go into effect. It is 90 days after the session ends. So we just don't know when that session is when the session will end this year. But through today, you can see on the screen there have been 1,780 bills that have been introduced. And of those bills, 238 have been signed by the governor as of today. Tells you a lot. I think it's kind of a consistent pattern every year that there's a whole bunch of bills that get introduced, and then by the end of the day, there aren't as many that get signed. I did note that recently there was a motion to have a senator from one of the legislative districts expelled from the Senate. That particular motion failed. I just thought that was worth putting on there. Just some interesting. You don't see that every day in our legislature. So again, I don't know when the session will end, but just stay tuned, and we will be sure to update everyone when it does. So there are 5 bills. I'm not going to talk about HB 2152 because it has very limited effect on communities, but it has to do with the Residential Contractors Recovery Fund. But I do want to talk about the 2 bills that have been signed, the HB 2131 and HB 2158. There are 2 bills that have yet to be signed, and that's why I've put them in this category of "so you're saying there's a chance" bills, because I think it's very likely that they will be signed. They have been held up for unrelated reasons. The first responder flag bill that we'll go over, that is very close. Condominium termination, maybe not as close, but that there is a chance that those 2 will also be signed before the session ends. And so we're going to go ahead and talk about them just in case they are signed. All right, so some of you have I'm sure most of you have heard about the artificial grass ban bill that that has made its way through the legislature. It has been signed by Governor Ducey. I know it's made its rounds on the news. There have been, there's been various coverage of it. So I want to make sure that for those of you who live in or manage planned communities, and again, this only applies to planned communities. It has no effect on condominiums. I'm not sure that there's many condominiums that have to worry about this, but this is planned communities only. There was let me just give you a little bit of history on this one. There is a community, and I'm not going to use any names, but there's a community in Paradise Valley. And there was an owner in Paradise Valley that got into a disagreement with her association over artificial grass and her desire to place artificial grass in that community. And there was a dispute over the amount of artificial grass that she wanted to put in, the type of grass, things like that. So as that's going on, she felt the need to take the legislative route, and she actually hired herself a lobbyist, and they started to make a push for some sort of bill that would help her or prohibit associations from doing what her association wanted to do. And this bill was introduced. It's not a new concept. For those of you who might recall, not many years ago, but I believe it was maybe 5 years ago, this similar bill was introduced. It obviously died and it wasn't signed, but they basically revived this bill. Another factor that's contributed to this is that the legislature this year, every year they seem to have a theme of what they focus on. There's been COVID in the last couple of years, there's the budget. This year, there's been all kinds of discussion about water conservation in Arizona. There are a lot of red flags that have been raised about the state of our water supply, the future of our water supply. And so there have been various bills and discussions about water conservation. So this kind of fit right in with that discussion. When this bill was first introduced, it was much different than what it is now. It had much different language, didn't have the protections for the association that it does now. I mean, we don't love the bill as an industry, but it is certainly better than it was when it first was introduced. And as a legislative action committee, we put a lot of effort into this one to try to improve it and change the language of what they were trying to push through. So this will be a new statute in the Planned Communities Act. It will be referred to as 33-18-19. It will be the last statute in the Planned Communities Act. So it is a brand new statute, which we don't get very often. Normally, we're just making revisions to current statutes. So this is a brand new statute for the planned communities. So it's all new language. So I want to go through this. And if you have that chart in front of you, you can kind of follow along with what it says. But essentially, the gist of the statute is that associations are going to be prohibited, with certain exceptions we'll talk about, but they will be prohibited, or they won't be allowed to prohibit the installation of artificial turf in their communities. But that what the statute, the way it reads, is that while they may not be allowed to, well, let me just kind of read from the statute here. In any planned community that allows natural grass on a property after the period of declarant control, so this is after the declarant is no longer there, the association may not prohibit installing or using artificial grass or turf on the member's property. So that's kind of the baseline rule there. That if you allow, so first it applies to those communities that allow natural grass. If you don't allow natural grass, then you don't have to worry about this. But if you allow natural grass, if you have natural grass in your front yards, and someone comes to you and makes a request to install artificial turf, you can't tell them no. Now, what the association can do is the association does have the ability under this statute now to adopt reasonable rules regarding the installation and the appearance of that turf. Now, they use that favorite word of ours, reasonable. Don't have a great definition for that. That's I usually say the word reasonable is what the person wearing the black robe behind the bench tells me it is. I think we can kind of know when something's unreasonable, but that's going to be up to the board through and I'm going to stress this through advice of your counsel, in formulating these rules, that you have to be reasonable. And so that's going to be a decision that the association is going to have to make as to what they think is reasonable. But again, it's regarding the installation and the appearance. Those are the things, is trying to govern to make sure that they don't put in really cheap looking turf, or the method of installation. There can be these rules that are imposed by the association to try to govern that and try to protect the appearance and of the community. It also says that the rules can regulate the location of the turf and the percentage of the property that's covered with artificial turf. So those are some other factors to consider when creating these rules. If this is something that you're worried about as a community and want to create these rules, again, remember the statute talks about you can have rules regarding location and the percentage of coverage. And you can also have rules regarding the quality of the turf, which kind of goes to the appearance factor of it. Now, I had a question come up to me the other day from one of my clients, is how do we even get started writing rules like this when it comes to appearance and quality of what turf is? And I'm not the source for that answer either. I have artificial turf in my front yard, but we just hired a guy, and he showed us some samples. We picked one we liked. And so trying to create rules, my advice to my client at the time was, you probably need to call a turf company and have them show you some specs, have them show you some samples. And you could even write that into your rules of, nothing less than this type of quality, or this color, or whatever it might be, and use those terms that are used in the professional services there. Try to be consistent with that, and that will help avoid any confusion or any vagueness in your rules. And you can try to get specific there when it comes to appearance and quality. Now, the statute goes on to provide the association with some other rights when it comes to turf. It does say that the association is allowed or may require the removal of a member's artificial turf if it creates a health and safety issue, and they don't correct it. Now, I've in preparing for this and in working through this law, I'm still struggling to think of an example of when artificial turf might create a health or safety issue. If any of you can think of one, please chime in. But I don't know that I have a good example of when that will happen. And it's probably going to be something that just pops up, and then we realize, oh, well, you know what, that is a health and safety issue, so let's go there. The association is also allowed to require the replacement or removal of the turf if it's not maintained in accordance with the standards that you set up as an association. So going back to those rules, you can enforce those rules. And if they don't abide by those maintenance standards and the rules that you have in place for your community, then you can require that they remove it or replace it. Now, also keep in mind too, when the way the statute's written is it starts out by saying, except as prescribed below, or in section B, you have to allow the grass subject to those rules. Subject B or subsection B of the statute says a couple things. One, you don't have to allow artificial turf if it would be installed in an area of your community that the association would normally maintain and irrigate. So, for example, you have a townhome, and under the documents, the association is required to maintain the front of the property. Okay, that is now the exception there. You don't have to allow them to install artificial turf if the association is otherwise maintaining that area. So keep that in mind when someone comes to you with a request, that if it is an area the association maintains and irrigates, you don't have to allow it. Now, it also does have some additional language that says if the association has some prohibition on the installation of new grass, of new natural grass, you can also prohibit the installation of turf. But if someone already has grass on their property, okay, that you're going to have to allow the turf unless one of these other exceptions applies. The legislature also felt the need to insert attorney fee language into this bill. So you got to keep that in mind as an association when you're going through this. If you want to try to challenge someone's application, if you're creating rules that maybe go a little bit beyond what's reasonable, The statute provides for an award of attorney's fees if an owner challenges you and wins. So please keep that in mind as a board, that while you have these rights under the statute, you need to be careful when someone comes to you with this request. Seek legal advice, try to, work through this carefully so that you don't find yourselves on the receiving end of a lawsuit where someone could recover attorney's fees if they were to win. Now, two things at the end of the statute that are kind of interesting, there are two kind of subparts of Section D of the statute. One says that this particular statute is not going to affect the association's responsibility, to carry out the intent of the CC&Rs and maintaining the appearance of and the standards in the community. I think that goes to the rules that you're going to create, the maintenance requirements, the standard and quality of the turf, that you still have the ability to do that to maintain a particular appearance in your community. But you are going to have to allow artificial turf under those certain circumstances. Now, the really interesting one, though, is the last exception to the rule. And it says that this statute does not apply to a planned community that has unique vegetation and geological characteristics that require preservation by the association. And it goes on to some other stuff. I actually had this question come up from a community here in, I think it's in Chandler or Mesa, I can't remember, but they have a lot of pecan trees. And there's a couple communities around the valley that have a number of pecan trees in their community, and it's kind of their feature. There's also the community up in Scottsdale, the Boulders, and other communities similar to that have a lot of geological rock features. If you meet that exception and you have that unique vegetation and those unique geological characteristics, you may be exempt from this statute. There may be an argument you can make that it doesn't apply, and you got to work through that, work through what your documents say, and make sure you have that argument that is supported by the statute. But you may be able to just right out of the gate say, you know what, as a community, this is the reason why we're not going to have to abide by this statute. This particular client I have, we feel that they do qualify for that exemption because of the way they are designed, because of the negative impact that artificial turf can have on trees. From what I've reviewed, it traps heat in the ground. It can disrupt irrigation and water flow, and there's concern that will impact the trees that are in this community. Now, I mean, it'll be interesting to see if communities try to use this exemption, and if there's litigation over it. But there is an exemption to the statute that they have drafted in there, so just be aware of that. So that essentially is the artificial turf bill. It was signed back in March, but it won't go into effect until 90 days after the session ends. So for those of you who feel that you have, if you're concerned about this bill and the impact it might have on your community, I would stress the importance of working with your attorney over the next 3 months to create rules, exercise your rights as an association to protect your community, and to have a procedure in place on how you're going to handle these requests if and when they come in the future. So, all right, moving on to the next bill. This is another bill, 2158. This bill actually came up, I think its original inception was back in 2020 when COVID hit, and for all those reasons, because of COVID and the way things kind of transpired during 2020 and 2021, it never really got any traction, but it just kind of got put on the bookshelf and dusted off for this session and reintroduced. Similar to the artificial turf bill, this bill was really bad when it came out. There was a lot of language that really wasn't going to be good for our industry, and we did work tirelessly with stakeholders and legislators to try to improve this bill. I will recognize right out of the gate, there's a lot of people that aren't happy with this bill. They're not happy that it was signed, but I'm going to tell you, no matter what efforts would have been done, it was going to go through. This bill sailed through. There was no objection for a reason I'll explain in a minute, because it is kind of a self-serving bill for legislators for their campaigning. But it sailed through. There was no objection to it, and so the effort was let's try to make it as good as it can be. knowing that it's going to go through, it's going to be signed into law. So there are, excuse me, I can blow my nose real quick here. There are multiple parts to this bill. Let's see here. Turn to the right page of the bill here. So this bill has two parts. One, it deals with political signs, and then the second part has to deal or deals with community activity, the use of common areas for gathering, for inviting guests to come speak, that kind of thing. So I'm going to cover each one separately. There was a push during this process there, and this is usually how this happens, as many of you know. You'll get one community out there that has a problem. It will get reported to those who are interested, and all of a sudden that exponentially grows into a statewide issue that maybe really isn't a statewide issue, but it's presented like that to the legislators that it's this is prevalent, it's pervasive, it has to be addressed, when in reality it's probably not anywhere close to as bad as the way it's being portrayed. And I feel like this is one of those issues that somehow they were able to convince certain people to run with this and make this law. So the first part of this bill deals with what are now going to be referred to as association-specific political signs. Just one second, real quick here. This is a new type of political sign that owners are essentially going to be allowed to post in the community, and the association is not going to be able to tell them no during a certain time frame. Just like political signs now, you have that 71-day window before an election and a 15-day window after an election. These association-specific political signs are going to be allowed, cannot be enforced against, subject to some restrictions, but it's during a little bit different window of time. But as you see on the chart, if you have that in front of you, let me just kind of go to the bottom of that second page, and you have the definition of what an association-specific political sign is going to be. And that was actually a phrase, the terminology that they ended up going with kind of had 3 or 4 different iterations. For whatever reason, they settled on this term as kind of the defined term. I don't know why. It just that was the term they liked. But these association-specific political signs are any signs that support or oppose a candidate for the board during an election, support or oppose someone for a recall, if you're having a recall of someone on your board, or support or oppose any sort of association ballot measure that requires a vote of the owners. So an amendment to your documents, a special assessment, maybe voting to borrow money or change your common areas, something where it requires a vote of the owners. Owners in your community are now going to be allowed to create these association political signs for or against one of those issues that comes up in your community. Now, yes.
There's a question in the chat.
Oh.
Political community activity. Can a homeowner go door to door to champion or campaign for a political party, cause, or ideology like LGBTQ within the community? That
is a good question. So this particular statute doesn't really address that activity. This is strictly related to signs. Now, I don't know that. I mean, I think generally speaking, I'm trying to kind of scroll through documents in my mind that I'm familiar with, that I don't know that type of activity would be prohibited in your documents as they currently stand. As long as they're not being a nuisance and not harassing people, I don't know that an association could tell an owner no, that you can't go door to door. And with this new thing, if you have, let's say I'm running for the board and I want people to put signs up in their yard in support of me as a member of the board, I don't think the association is going to be able to tell me no. I think I could go door to door. I think I could, campaign for that. Now, other ideologies within the community, again, I think it's just going to have to come down to the actual activity itself and what's actually taking place. I don't know if there's a blanket statement that says you can't do this, and I would be very careful with even saying something like that, that you can prevent someone from doing that. So,
And there would be, she mentions it's Donna, and she says that it's a gated community.
it is a gated community. So, okay, that could change. That could change the nature of things. If we're talking about outside people coming in to campaign for an issue, I think if outside people aren't allowed unless they're a specific guest of an owner, I think that is still enforceable. I mean, it is your private property. This statute does not open the door for campaign activity, at least the way I read it. I think it's more about just internally within an association dealing with association issues. Okay, this all this really is. It's just adding in because someone felt the need to be able to campaign for themselves or campaign for a particular issue, and the association's been telling them, no, you can't do that. So we have to allow signs now for those issues that people feel strongly about an association issue. So I hope that answers the question. I did see, I'm kind of going back up. There was a comment, a message earlier. It says something, if it's not cleaned up correctly regarding dog feces, urines. I think that's probably a reference to the artificial turf and maintenance of it. It was from Suzanne. I don't know, Suzanne, if you want to re-ask that, I can try to answer that. But going back to that to the statute then, and Donna, if you want to chat offline about that, we can, if I didn't fully answer your question. But while we have to allow these signs in our communities now, there are still some things we can do. And there's some things we can't do. So I want to go through that list. You can still establish reasonable rules regarding the placement, location, and the display of these signs, these political signs, association-specific political signs. But as you see on the chart, though, you have to allow them from the day that you send out the ballot for whatever it is, for the board meeting, for the board election, for the removal, or for the association ballot measure, whatever that is. From the date you send out that ballot to the community up until 3 days after the actual meeting takes place, where the vote is tallied, you have to allow those signs to remain on the property. You can't tell people to remove the signs. It's similar to the 71 and 15-day period. It's now from the date that the ballot goes out to 3 days after the election. We can't limit the total number of signs, but similar to the political signs, if the total square footage of those signs exceeds 9 square feet, you can regulate that. So, that might be difficult. I mean, I don't know that you're going to go on someone's property and measure it, but I think you're going to know it when you see it if it exceeds 9 square feet. You cannot require that their signs be commercially produced, professionally looking. I mean, if someone just wants to put up a poster board with handwriting, I mean, you're going to have to allow it. You can't prohibit the use of both sides of the sign. You can't regulate the number of candidates or number of issues that they support or oppose. And then one thing that we added in, one thing that we were concerned with with this bill is the possibility that owners will use this as a sounding board to essentially defame or harass their neighbors. They don't like Bob Smith as the board president, and Bob Smith is a crook, and he's done X, Y, and Z. I'm going to put signs on my property, essentially defaming Bob Smith, because I'm allowed to put signs on my property now because I oppose his reelection to the board. The legislature was aware of this, was made aware of this, and that's why the last part of that says that the association is allowed to create regulations regarding the content of that sign, so long as that content regulation is limited to prohibiting profanity and any sort of discriminatory texts. Now, and that discrimination is linked up with the fair housing kind of analysis, the protected classes that would otherwise fall under fair housing. You can't have any sort of discriminatory signs, and then if there is profanity, you are allowed to regulate that. Now, what is profanity? I guess it's kind of like the famous Supreme Court case of what is pornography. You kind of know when you see it. But that is something that the association will be able to try to regulate if you do come across that, those types of issues. If it doesn't fall within one of those categories, though, you're going to have to allow the sign to be posted on the property.
So Cliff asks Quinten, no solicitation, going door to door, could that cover a community from activists?
No solicitation, question mark.
Perhaps Cliff needs to explain his question better.
And Cliff, if you're able to unmute yourself and maybe ask me, I'm not sure I understand your question.
My question was, if a community has no solicitation, meaning any groups at all coming in to either fundraise or whatever, if you had a bunch of activists within a community that decided to go door to door to push for a specific ideology or whatever, would that help the community to stop that from happening by saying that's a form of solicitation?
So okay, I understand the question. I don't think this bill, I think we're talking maybe two different things. I don't think this bill helps or hurts or affects what's already in place in your community. If you have no solicitation and you already prohibit that, this doesn't change that. You still have the ability to say no solicitation.
Gotcha. Thank you.
This bill is really just limited to signage that's posted in someone's yard for a specific association purpose. So that's a good question, though. All right, so that's where it stands now on these association specific political signs. One of the concerns that came up was the amount of signage that may pop up in your community. You know, you may have an election in March, you may have a community vote in September for something. You know, there is that possibility that you could have signs for multiple months in your community. I'm kind of in the camp where I'm not as concerned about that, because in reality, I don't think associations they typically don't have multiple community votes during the year. A lot of communities will just link that up with the annual meeting and vote on it there. Sometimes things come up, special assessment, something where you need to vote. And so you may have a second wave of signs, but I don't know that we're going to be inundated with signs all the time, because there is that fixed window of time that they get to put up the signs. But just remember, it's the day the ballot goes out, up until 3 days after the election. All right, moving on to the second part of that new statute, has to do with, and this is the part that I think had a lot more people concerned with the bill. And this was also one of those examples of where someone, I think, made a mountain out of a molehill. I mean, as it stands right now, any association that has common area, an owner has an easement right to use the common area. And you can't tell an owner they can't use the common area unless maybe their rights have been suspended, you know, whatever that might be under your documents. But they felt the need to enact this bill now that trumps your documents. It starts out by saying, notwithstanding any provision in your documents, an association may not prohibit or unreasonably restrict an owner's ability to peacefully assemble and use the common property. Now, it goes on to say, so long as that's done in compliance with reasonable restrictions that are in place, that have been adopted by the board. So let's kind of unpack that a little bit. So you can't prohibit or unreasonably restrict, but you are able to still have restrictions in place when someone wants to use and assemble on the common property. One of the questions that's come up throughout this process is, you know, let's say you live in a community that has a real nice clubhouse, and anyone who wants to use that clubhouse for an event has to rent it. Okay, I think that could be still considered a reasonable restriction. It applies to everyone. You would have to rent that, and I don't know that this bill, the way it's written, would force an association to let someone use it for free. I think there's still that. And there's also the behavior thing. How do they use the common property, the times of day, things like that you might already have on the books that you can continue to enforce even with this new rule. So similar to the turf bill, associate.
Sorry, Tracy wanted to know, what about the placement of a sign in a condo setting?
Oh, you know what, Tracy, thank you for bringing that up. I failed to mention, let me go back to the sign issue. So that the signs, similar to political signs in condominiums, you have to allow them to post it in their unit or in the limited common elements that essentially touch the unit. So the balconies or next to the front door, something that's in close proximity and touching the unit. Same thing applies for these types of signs. So that the same sort of enforcement or rights that they have on the placement of those political signs is going to apply to the association political signs, if that makes sense. So anywhere someone was already allowed to place a political sign, they're going to be allowed to place this association political sign going forward. So hopefully that answers your question, Tracy. I appreciate that question. So this assembly bill then, it does allow these owners or a group of owners to assemble on the common property to discuss essentially any association matter. The bill spells out a couple things, talking about elections, talking about recalls, talking about ballot issues, property maintenance, things like that. They have that ability to assemble. Their assembly on that common property, unless it's noticed as a meeting of the members, is not going to be considered a meeting of the members. So if you have a group that would otherwise form a quorum of the members, it's not going to be considered a members meeting unless they follow the open meeting laws in doing that. Now, the part of this bill that really got the attention of the legislators and caused it to really sail through the process was that a unit owner is entitled to invite one political candidate or one non-unit owner guest to speak to an assembly of the unit owners about matters related to the condominium. They're going to be allowed to bring someone in. Now, the way it's written, though, and I don't know if this was an oversight or not, but it says a unit owner may invite one political candidate. Once they've invited that one political candidate, I think there's an argument out there that they've used up their political candidate, their opportunity. It doesn't say once per year. It's one. So something I think may come up on that later, as we kind of work through this. And those owners, if they want to have these gatherings, you cannot prohibit, the association is not allowed to prohibit them from posting notices of that assembly on the common elements or within those common property facilities. If they want to post flyers for the gathering, you're going to have to allow them to do that. Even if you have restrictions that state otherwise, you're going to have to allow them to post those notices. Now, you might be able to have some sort of restriction on what they look like, but you can't tell someone they can't post a notice. That is now prohibited by the statute. So that's where it is. These owners now going forward are going to be allowed to use the common property to assemble. They can invite that guest to come onto the property. There were concerns raised about the safety concerns, the use of that property. I think a lot of those concerns can and should be addressed through those reasonable restrictions that you have in place for the use of your common property. This law allows that. The law allows you to have those in place. And so as a board and as a community manager, in anticipation of this bill going into effect in the next 90 to 120 days, start thinking about that. Work with your attorney to come up with, if you don't already have restrictions in place, come up with something that's reasonable in anticipation of owners trying to use this bill to their advantage. So that is House Bill 2158. I'm going to, just in the interest of time here, let me move through a couple of these. So the two bills that are still on the table, they're still being, excuse me, being tossed around, going through different reads, different committees. One is the condo termination bill, House Bill 2275. This is another bill that was resurrected from years past. Some of you may recall, I believe it was last year, there was a news story on ABC 15. The news went out and found an owner. You know what? Before, let me just. There's a question here on the last issue that I want to make sure I address. So the question is, will quorum requirements matter for this? And we're going back to the assembly bill. Will quorum requirements matter for this if more than a majority of the board are part of this peaceful assembly? the quorum requirements do not matter for owners. You know, if your quorum requirement is 10% of an owner to have a meeting of the members, that's not going to matter. If 3 out of your 5 board members go to this assembly, that may not matter too. It just depends on what those board members do. Remember that the open meeting laws say that if you have a quorum of board that are together discussing association business, then you have to notice that meeting under the open meeting law. So if they're just there listening, not participating, not discussing anything, I don't think that's an issue. But if those board members start discussing what's going on, discussing association business, now they have a quorum. Now you have to worry about the open meeting laws there. So hopefully that answers that question. But back to the termination bill quickly, there was a lady in a community in Phoenix that was going through their condominium was going through this termination process. And as you all probably know, the current statute 33-12-28 of the Condominium Act allows a condominium to be terminated with the vote of 80% of the owners. Then the 80% can force the other 20% to sell. There's an appraisal process, and you can force the issue and terminate the condo. They found a lady who was part of that 20%, and it was an elderly individual that had no idea where she was going to go. She's being forced to sell, and it kind of tugged at the heartstrings of some legislators, and they felt that they needed to act on this. And so where the bill stands right now, if it were to go through today, is that the legislature is trying to impose a 100% requirement to terminate a condo. They say that if you want to terminate, all 100%, all owners in the condo have to sign off on it. I think you can all kind of imagine how ridiculous that is and how that would never happen. So we've been trying to negotiate. Is there a different number we can go with? They're stuck on this 100. There is now, as of late, there's been a challenge. There's maybe not really a formal challenge, but there's been issues raised as to whether or not this bill is constitutional. That would be something that would probably be raised after the fact. If the bill goes through, someone might challenge the constitutionality of it. There's also talk about, maybe there is an effort to make this so it's not or essentially grandfathering in current condominiums. So it won't impact any current condos. It would only apply to future builds. So the final language has not been settled on this, and it's not ready for the governor to be signed. So, and there's still a chance this thing could fail. And out of the 2 bills, this one probably has a better chance of not getting to the governor's desk. But I want to bring it up just because there is a chance that it still could. The other bill that I think has a much better chance of getting to the governor's desk is the flag bill. Again, this was another attempt from a year or 2 ago to change the current statute in the Condominium Act and the Planned Communities Act on the types of flags that the associations are not allowed to touch. As long as they, display it properly and follow the other rules, the association, as it currently stands, there are 5 or 6, I don't remember the exact number, but there are a handful of flags that we can't do anything about as an association. One of the things this bill will do is if you do look at that statute, like 33-1808, for example, it does, when it talks about that list of flags, it first talks about the American flag, and then it lists the flags of the different armed services. This bill, if it goes through as proposed, it will actually change that first part to say American flags and then any uniform service flag, which essentially is just an umbrella term to cover all the military flags. So it doesn't really change that, it just changes the way it's referenced. But the big change to this bill, or the big change that would come from this, is going to be what's referred to as a first responder flag. And first responder flags will be on that protected list. And first responder flags could be one particular flag or a combination of various flags that fall into that definition. There's also an attempt to add to that list what's referred to as the Blue Star Service flag or the Gold Star Service flag. So as far as the first responder flags are concerned, there are 3 there's 3 subcategories to that definition. One would be a law enforcement flag that is limited to the colors of blue, black, and white that use the words law enforcement, police officers, first responders. We support the police, things like that. That would all fall under that definition of a law enforcement first responder flag. There's the fire department, limited to the colors red, gold, black, and white, and with different words like fire, firefighters, FD, and the same sort of support. And there's also the Maltese cross that could be included with that. And then there's also the third category would be paramedic flags and EMT. It's a blue, black, and white color combination. Words first responder, paramedic, emergency medical, things like that. And there's also what's referred to as the Star of Life. Now, on my next slide here, I found some of the flags of what examples, I guess, of what some of these flags might look like. Okay. We've seen the blue line flag, that thin blue line flag with the blue line and that black and white American flag. That right there, or something like that, is going to fall under that category. The one on the left there, you see with the blue, almost like a Dallas Cowboy star, that's your Blue Star Service flag. And on the right side is the Gold Star Service flag. That's a recent addition to the bill that, if signed, would include those flags. The bottom flags are examples of what a fire department flag might look like. The Maltese cross that they use for the fire department, or an EMT flag. And then that one in the middle is that generic Star of Life kind of flag. So, but remember, the way this bill is written is it could be a combination of these. It could be all kinds of variations of this flag. And that's, I think, where associations are going to have a tough time, maybe for the community managers, more importantly, of trying to enforce this. But just know that just know that it's not one, like, for example, this thin blue line police department. That's not the only one. You could have probably 10 others that meet those color requirements, the word requirements, and it could be a combination with police and fire, or police and EMT. So it's a very broad brush that they've painted here, and I think you have to be aware of. Now, there was a comment here, and I appreciate this comment from Kevin. Under uniform services, you have Army, Navy, Marine, Air Force, Space Force, that recent Space Force, Coast Guard, National Oceanic and Atmospheric Navy, and NOAA, U.S. Public Health Service. So there are some additional services that weren't specifically referenced in the past iteration of that bill. So just be aware of that uniform services is going to broaden that scope of what's allowed. So just going forward with this flag bill, if it is signed, again, it has not been signed, but just be aware of all these types of flags that the association will not be able to restrict or prohibit in your community. So with that, are there any questions about the bills themselves? Now, in the last couple minutes that we have remaining, I did want to just real quickly, some of the bills that were introduced this year that had a short shelf life. There were efforts to make amendments to the CC&R amendment provisions. This was done before this Callaway decision came out, and all these bills died before that decision came out. So I think there will be something revisited next year in light of that decision and in light of the efforts that were being made prior to that decision. It's very likely we will see some sort of effort next session on CC&R amendments. There was an attempt to revise the homestead exemption law. Every year there are efforts on short-term rentals, but for the last, I think, 3 or 4 years, all of those efforts have been localized to or concentrated on the ability of the state, town, city to enforce rentals. It has no direct impact on associations, and I don't think there will be. I mean, there's no indication that there's going to be a bill that will impact associations in their ability to restrict short-term rentals next session, but who knows? It always seems to come up, so maybe there will be. There was also an attempt this year to restrict an association's ability to restrict solar and water saving devices. If someone wants to collect water, someone felt the need. Again, that goes to that water conservation theme that was in the legislature. So we'll see what happens next year. It's always exciting that those first couple months to see what people are thinking. But
Can you quickly do a code word for me?
oh yeah, I actually wrote that down at the beginning. So the code word for the class today will be artificial turf. Artificial turf will be your code word to get that credit for the CAI, that your credit for your designation. So the last slide I have here, these are three, and I just, in the interest of time, I'm not going to go into some of these in great detail, but these are cases that have come down and been decided within the last year and a couple months. I did not talk about these last year. This Sycamore Hills versus the Blotney case was a case that was decided in January of last year, but I didn't become aware of it until, actually, in full disclosure, I didn't become aware of it until recently because of a case I have. What this case stands for is in this case, the association entered into a settlement agreement with the defendant in a lawsuit. They were involved with an owner. They entered into a settlement agreement and a stipulated judgment. Fast forward, I can't remember the exact time frame of how long it happened, but I believe my understanding is it was a new board, or a couple new board members got in place, and they looked at this settlement agreement that the board had entered into, and they realized that the settlement agreement was in direct violation of the CC&Rs. I don't have the specifics of what the settlement agreement said. Some of you might be aware of that, I don't know, but essentially it was, wait a sec, we can't agree to this because it violates our CC&Rs. We're treating them differently. We don't have the authority to agree to what we agreed to. And so they asked the court to set aside that judgment and set aside the settlement agreement, saying that we didn't have the authority to do this. And so they were essentially challenging the actions of a previous board and their authority to do that. There is a provision in the Nonprofit Act, it's section 10-3304, that directly addresses this issue and says that if an association wants to, or if someone wants to challenge the actions of a board, there's only two ways you can do that. Either an owner or a group of owners has to file suit to challenge the association, or the association can pursue the previous board members individually for their actions. But an association cannot sue itself essentially, or challenge its own decision from previous years. And I have a case right now where the other side's attorney is trying to use this argument against us because the issue before the court is an action that a board took back in 2011, I believe. It's an assessment issue. And there's a question over whether or not they had the right to do that. And they've kind of put us into this corner saying you can't question what your previous board did because you didn't sue the board members. You didn't, the owners didn't bring suit to challenge that. You're challenging yourself. And the court has agreed with this. It's kind of put us in a bit of a tough spot, but just be aware of that if a board makes a decision, there's only certain ways that you can try to challenge that decision. The Watson versus Leisure World Community Association was a CC&R amendment challenge case. This predates the Callaway decision. This was from last year, but it just quickly involves some amendments that were passed or recorded, I should say, and an owner challenging the association's recording of the amendments, saying that they didn't have approval of the owners to do one of them, that they didn't have the consent forms that they used weren't proper. And really kind of the interesting claim was that recording these CC&Rs that weren't done properly were a violation of the wrongful lien statute. Some of you may be familiar with ARS 33420 that says if you record a lien that has no basis in law, you can be subject to a $5,000 penalty for recording that lien. And without going into all the details, the court found in favor of the owners in this case and said that the amendments were invalid. They didn't follow the right process, and they violated 33420, which held them to a statutory damage of $5,000. And when this case was going up to the appeals court, the lower court had already awarded the owners attorney's fees to the tune of $116,000 against the association. plus statutory damages and some other penalties that they tacked on. So it was and I don't know what the final number was resolved on that the Court of Appeals decided on, but it was I read it as a lesson to the association on how to properly enact CC&R amendments. Well, stemming from that case and now segueing into this recent case, the Cowway versus Calabria Ranch decision, the reason I wanted to bring up that Leisure World case is because based on this Cowway decision that I'm sure all of you have seen the summaries from the different law firms, what happened in that Leisure World case, I'm afraid and have some fear that you're going to see that happen a lot more as owners look at this Cowway decision and decide, you know what, I'm going to challenge those amendments that the association did, and I'm going to say it's a wrongful lien, and we're going to get all kinds of damages against the association. So in the last 3 or 4 minutes, just quickly on the Cowway decision, for those of you who maybe haven't read it, just a couple things I want to point out. As you may know, it was a small community in Tucson of 5 homeowners, 5, and this tiny little community has now set precedent for all of us that we have to follow. But you essentially had a group of 5 owners, 4 versus 1, and the 4 decided to amend their CC&Rs using the amendment language in their document that allowed for a majority vote, and they made sweeping changes to their 2015 document, dealing with lots, building sizes, lot splits, garages, livestock, improvements to the community, all kinds of changing definitions, creating new maintenance obligations, kind of the whole gamut. They changed it all. Well, the owner challenged, and it went up to the court. Court of Appeals ruled in favor of the association, and then the owner appealed to the Supreme Court. And for those of you who have been in this industry long enough, you know that a HOA case making it to the Supreme Court does not happen hardly ever. And so it was quite surprising to see the Supreme Court take this case. And then even more surprising was the way they reasoned their way through this to get to the conclusion they wanted. And I say it like that because I really think they had that conclusion in mind. And one of the reasons I say that, as you look at the case, they were citing the cases out of Nebraska, North Carolina. I think they went to Illinois to try to find support for their decision, which courts can do, but it was just very interesting to see that the way they came down on that. But essentially what this case now is requiring us is it says that if you want to amend your CC&Rs, you can still use the provision to amend that's in your documents. However, it does say that, and I'm reading from the case here. We hold that a general amendment power provision, which would be your 67%, 75, may be used to amend only those restrictions for which the HOA's original declaration had provided sufficient notice. So they go through this whole analysis of what do your current CC&Rs say, and what are owners on notice of when they buy their property. So when someone buys into a community with CC&Rs, they read their CC&Rs and they say, I can do X, Y, and Z. If the association wants to amend, to change something, to add new restrictions, to add a new maintenance obligation, okay, the argument's going to be, well, we didn't have notice that those restrictions would ever come into play. And if you want to put them into play, that's fine, but you need my approval. You know, me as an owner, I have to sign off on that if you want to do that. Now, if you're just simply amending to revise current language, to update, maybe to bring it into compliance with the law, you know, people are on notice of that already. You have existing language, but it's those new restrictions that, as the court refers to it, new restrictions are essentially not reasonable and not foreseeable. So if your restrictions are not foreseeable and they're not reasonable, a court's going to strike them down. And so this has created this atmosphere now in our industry where two things. One, if you want to amend your CC&Rs going forward from today on, or from whenever this case was decided, you're going to have to be very careful. You're going to be very limited in the types of amendments you can make and without 100% approval. I think what concerns me more about this case, though, is the retroactive applicability of it. If you amended your CC&Rs a year ago, 6 months ago, 4 or 5 years ago, maybe even 10 years ago, there is an argument out there that someone could challenge that amendment. If let's say you put in rental restrictions 4 years ago because of the other change in the law, and you didn't get 100% approval for that rental restriction, and your previous CCNRs made no mention about rental restrictions, an owner could challenge that, and I think an owner would be successful with that challenge. So at least in our office, I had done personally on my desk, I had 5 or 6 amendment projects in the last couple of years, and I've lost some sleep over that because I don't know what's going to happen. Now, it is going to take a homeowner, willing to pay to challenge that and bring that to a court's attention. And so it may not happen as much as we think, but I can tell you this, the attorney's offices out there that represent homeowners are actively marketing this. They're actively telling their homeowners, hey, if you want to challenge your CCNRs, give us a call. We can talk. And we've already received multiple demands and letters in our office regarding this issue, kind of putting us on notice, hey, we're going to challenge your CCNR amendment. So I'll leave you with this on amendments. If you're working through that process right now, if you want to amend, you still can. There's ways to do it, but you're going to be limited in what you can do without full approval. And you just really have to be careful in the way you change your documents. So with that, if there's any questions, chime in, you can ask. If you want to send me an email, I think I put my email here. There's my email address at the bottom of the screen. Feel free to send me an email. And again, the code was artificial turf for those of you who need credit. And I appreciate your attendance today.